Welcome to Prince Shorten House. Legal exercises 22, 23, and 24. 120 words a minute, non-stop. Real judgments, legal. Ready? Start. An affidavit purported to have been signed by the appellant was filed with the bank to make him the second guarantor. Appellant had never signed the document and his signature was forged. A writ petition was filed before the Allahabad High Court to quash the notice issued by the bank. The writ petition was dismissed, giving liberty to the appellant to seek appropriate remedy. On 13th July 1998, an application was filed before learned CJM alleging commission of offences by the named accused persons. Learned CJM directed the police to register and investigate the case. As noted above, on the basis of order of learned CJM, the FIR was registered. The essence of the grievance of the appellant was that the accused persons, with the help of the bank manager, made forged signature of the appellant in the agreement form and an affidavit to show him as a guarantor. After investigation, charge sheet was filed by the police on 13th September 1999. On 24th May 2000, respondent number 1 filed the application under section 482 of the code for quashing the FIR, the charge sheet and the order of learned magistrate by which he had taken cognizance, and the order directing the police to register the case under section 156 of the code. By the impugned order, the High Court quashed the charge sheet on the ground that the magistrate had no power to order registration of the case. In support of the appeal, learned counsel for the appellant submitted that the order of the High Court is clearly contrary to law, and on misreading the provisions contained in section 156 of the code. Learned counsel for the respondent number 1 on the other hand submitted that the true scope and ambit of section 15 of the code has been kept in view by the High Court, and the impugned order does not suffer from any infirmity. Learned counsel for the state supported the stand of the appellant. In order to appreciate a revival submission, section 156 of the code needs to be quoted. The same reads as follows. Police officers' power to investigate cognizable cases. Point 1. Any officer in charge of a police station may, without the order of magistrate, investigate any cognizable case which a court having jurisdiction over the local area within the limits of such a station would have power to inquiry into or try under the provisions of chapter 13. Point number 2. No proceeding of a police officer in any such case shall at any stage be called in question on the ground that the case was one which such officer was not empowered under this section to investigate. Point number 3. Any magistrate empowered under section 190 may order such an investigation as above mentioned. Section 156 falling within chapter 12 deals with powers of police officers to investigate cognizable offences. Investigation advices in section 202 contained in chapter 15 is different from the investigation contemplated under section 156 of the code. Chapter 12 of the code contains provisions relating to information to the police and their powers to investigate, whereas chapter 15, which contains section 202, deals with provisions relating to the steps which a magistrate has to adopt while and after taking cognizance of any offence on a complaint. Provisions of the above two chapters deal with two different facets altogether. though there could be a common factor, that is complaint filed by a person. Section 156, falling within chapter 12, deals with the powers of the police officer to investigate cognizable offenses. Stop. Next, exercise number 23. Mr. Naveen Nath, the learned counsel appearing on behalf of the respondents herein, on the other hand, would support the judgment of the High Court, contending that a finding of fact has been arrived at by the High Court that there existed a relationship of employer and employee between the state and the concerned employees, as the state exercised total control over them, and therefore this court should not interfere therewith. It was contended that the employees of the canteen, in view of Article 14 of the Constitution of India, were entitled to parity in wages with that of the employees of the state government for the period they had worked, and furthermore they have been in such employment for a long time. Their services have rightly been directed to be regularized. The canteen was being run by private contractors for a long time. In the year 1974, the state of Karnataka intended to run the canteen by a committee consisting of 10 persons, 6 of them representing the government and the remaining 4 representing the association, as mentioned in order dated 19th November 1974. Amenities and facilities, premises, furniture, cooking utensils, crockery, and cutlery, etc., for running the canteen were to be provided by the state only for a period of 1 year. The chairman of the committee is requested to take action to start the canteen. The working of the canteen under the above arrangement would be reviewed at the end of the 1 year, and then the future setup shall be decided. The state, by reason thereof, thus made a provision for grant of rupees 25,000 in terms of the said scheme. All the furniture and equipments which were handed over to the committee were required to be accounted for and returned to the government upon the closure of the canteen. The employees were appointed indisputably by the committee on an ad hoc basis oblique daily wages. It furthermore appears that the government had sanctioned grant in aid from time to time. The management of the said canteen was handed over to the respondent association. Constitution of the managing committee was being changed on a regular basis. In the order dated 27 July 2000 issued by the government of Karnataka, it was stated that this canteen is running under a constant loss for the past few years, and consequently government had to sanction grant in aid a few times. These grant in aids were sanctioned keeping in view the welfare of the secretary employees. In the background, all the members of the management committee have tendered their resignation to government with a request to make alternate arrangements in view of the fact that they are unable to run the canteen on no profit, no loss basis, and also considering the fact that government has not agreed to give further grant in aid to the managing committee. In this background, a meeting was convened under the chairmanship of Additional Chief Secretary to Government to consider making alternate arrangements for running the canteen. Finally, in a meeting convened on 23rd February 2002 under the chairmanship of Secretary to Department of Personnel and Administrative Reforms, it was decided to hand over the management of the canteen to Karnataka Government Secretariat Employees Association temporarily for a period of 1 year commencing from 6th April 2000, and It is also proposed to continue the existing grant in aid and other facilities to Karnataka Government Secretariat Employees Association for running the canteen. Apart from this, it is also proposed to provide the services of six secretariat employees for supervising the affairs of the canteen by treating them as on other duty for a period of 1 year. Stop. Next. Exercise number 24. It is interesting to note that such claim was accepted by the assessing officer as a matter of fact, but he had expressed the opinion that the SSC was likely to generate some revenue in the subsequent years due to market potentiality of the softwares developed by it, and hence it has the nature and character of capital expenditure having enduring benefit. The actual backdrop of the cases in which the amount has been treated to be capital expenditure is different. In the case of Jonas Woodhead, the foreign firm had not only furnished the information and the technical know-how but rendered valuable services in setting up of the factory itself, and even after the expiry of the agreement there was no embargo on the SSC to continue to manufacture the products in question, and on that basis a percentage was fixed. The present case is not one where one can say that there is exclusive right to use the patent or trademark of any foreign company, or there is payment of royalty on the gross turnover. The said agreement provided for the supply of technical know-how that the INA had already developed, being in the same line of business, for a lump sum consideration of rupees 3 lakh and subject to Indian tax, sold the same to the SSC. Clause 7 of the agreement postulated that the lump sum amount was to be paid in installments. The income tax officer treated the said expense as capital expenditure. Eventually, the tribunal allowed the claim of the SSC and treated the expenditure as revenue expenditure. The division bench referred to the decision in Jonas Woodhead and came to hold that when the SSC was allowed to use the technical know-how even after the expiry of the period of the agreement, there is no doubt that the SSC had acquired the benefit of enduring nature. In our considered opinion, the facts in the said decision are quite different from those in the case at hand and hence distinguishable. In the present case, from the order passed by the CIT, it is noticeable that the said authority has taken note of the nature of business of the SSC and also appreciated the stand that the SSC was engaged in the business of development of software and marketing thereof, and hence there was no logic in the finding of the assessing officer that the softwares may not have long life in the following years, but some value should be assigned to them at the end of the year. That apart, the first appellant authority has not accepted the reasoning ascribed by the assessing officer that the SSE may not be able to develop the software to its final stage, and the expenditure incurred during the year may result in no income. The CIT has also recorded that the assessing officer has not analyzed the material brought on record and added the amount purely on the basis of guesswork, which is impermissible. The tribunal, as is evident, has held that the expenses were routine in nature and the addition of 25% could not have been disallowed on the ground that the SSC was likely to generate some revenue in the subsequent years due to the market potentiality of the softwares developed by it. It is worth nothing that the tribunal has opined that the very nature of the expenditure was revenue, and even if there is any advantage, it would be in the revenue field and not in the capital field. Thus, the conclusion arrived at by the tribunal cannot be said to be flawed inasmuch as there is no material on record that the expenditure was capital expenditure. Stop.